BPD's discharge of firearms at moving vehicles are highly dangerous, ineffective, and may be constitutionally impermissible. BPD officers shot at moving vehicles in 8 cases during the time period we reviewed. Shooting at a vehicle that is fleeing away from officers is unreasonable except in rare circumstances. See Waterman v. Baton with no date. Once Waterman's vehicle passed the officers, the threat to their safety was eliminated and thus could not justify the subsequent shots. Plumhoff v. Rickard found that officers' use of deadly force against fleeing suspects reasonable where suspect engaged in outrageously reckless driving, leaving officers on a chase that exceeded 100 miles per hour and passing more than 24 vehicles, several of which were forced to alter course. In some of these cases, although the factual descriptions were incomplete, it appeared officers may have fired shots at individuals in moving vehicles as the vehicle was fleeing away from them. At that point, the vehicle itself no longer posed a serious threat to the officers, and if it posed a threat to others, shooting at it likely increased the threat rather than eliminating it. The investigations of these incidents often left crucial questions unanswered, however, making it difficult to determine whether the officers faced an immediate threat of serious harm before discharging their weapons. Nevertheless, supervisors and investigators generally approved officers' decision to fire shots at moving vehicles. Additionally, shooting at a moving vehicle is highly dangerous and an ineffective way to stop the vehicle. Using firearms against a moving vehicle often creates greater risk than it eliminates. If a driver is shot while a vehicle is in motion, the vehicle itself may become out of control and a danger to officers and innocent bystanders in its path, rather than coming to a stop. Further, a moving vehicle is a difficult target to shoot with accuracy. Shots fired may miss the intended target and hit bystanders or passengers in the vehicle. Thus, shooting at a moving vehicle should be permissible in only extreme circumstances. Since 2006, the IACP's model policy on use of force has accounted for these risks, requiring firearms shall not be discharged at a moving vehicle unless a person in the vehicle is immediately threatening the officer or another person with deadly force by means other than the vehicle. The moving vehicle itself shall not be presumptively constitute a threat that justifies an officer's use of deadly force. An officer threatened by an oncoming vehicle shall move out of its path instead of discharging a firearm at it or any of its occupants. This is a situation that occurred in that Chicago shooting of Paul O'Neill. Officers were firing their weapons like crazy at a moving vehicle, and this was against Chicago policy, which you can see where they got the policy from. Two illustrative incidents identify some of our concerns with BPD's use of firearms on fleeing vehicles, although we make no finding on whether the force used in either of these incidents was unreasonable. In one 2013 incident, an investigation into a possible drug transaction ended with an officer firing 7 shots at the front, side, and rear of a vehicle as it drove away. One of the 3 officers on the scene observed that he suspected was a drug transaction in progress in a car parked near a gas pump and signaled to the other 2 officers to investigate. One officer approached to the driver's side door of the vehicle and the other to the passenger side. The officer at the driver's side, reportedly fearing the driver was reaching for a weapon, opened the driver's side door and reached inside while the car was still running. He does not appear to have ordered the driver to turn the engine off. Rather than reaching for a weapon, the driver had put the car into drive. With the officer's torso inside the vehicle, the driver hit the gas and the car sped forward. The officer, becoming caught halfway into the car, was dragged by the car. He reached for his weapon and fired 1 shot towards the driver of the car, missing both the driver and the officer standing on the other side of the vehicle. The officer's gunshot reportedly caused the driver to jerk the car, dislodging the officer from the car. The vehicle turned to exit the parking lot, driving towards the 3rd officer who had observed the incident. According to BPD's documents, the third officer stepped out of the way of the oncoming vehicle and then fired 7 rounds, 2 of which hit the front windshield and 5 of which hit the right side passenger windows and rear passenger window, shattering the rear windshield and hitting the rear roof of the car. The officer admitted during a brief 15-minute interview BPD investigators conducted 258 days after the incident that he shot at the vehicle as it was fleeing away from him. It appeared he shot at the vehicle, which had fled the wrong way down a one-way street, to disable it, though BPD officers conducting his interview did not clarify this point. BPD determined all force in this incident was reasonable. In another incident from 2013, 2 officers were on foot directing traffic near a crowded nightclub. A civilian car traveling the wrong direction struck the 2 officers from behind, knocking them to the pavement. The car then started to leave the scene. One of the 2 officers fired 8 shots at the vehicle as it was fleeing away from him. In this case, investigators determined the discharges to be inappropriate. In our review, we observed additional incidents of firearm discharges at moving vehicles which, even if they were not unreasonable, endangered members of the public. The disparate treatment of the officers in these 2 incidents may have resulted from the clear lack of policy guidance on which the officers might be justified in shooting at moving vehicles. The department's 2001 use of deadly force guidelines instruct officers that they may not shoot at vehicles moving away from them unless the vehicle turns around and attempts to injure them or someone else and adequate cover is not available. However, guidelines function differently from policies. They are not binding on officers. The prohibition on shooting at vehicles moving away from officers was not made clear in policy until May 2016. The department now prohibits shooting at moving vehicles unless confronted with a deadly threat other than the vehicle itself. This new policy prohibiting shooting at moving vehicles regardless of whether they are fleeing is a positive step forward. BPD's deficient policies, training, crisis intervention program, and a lack of oversight underlie a pattern or practice of excessive force and violations of the Americans with Disabilities Act. BPD's deficient policies, training, crisis intervention program, and failures in oversight over force incidents underlie a pattern or practice of unconstitutional force we observed. It is the department's responsibility to articulate policies that provide sufficient guidance, both in quality and content, to officers on when and how it is appropriate and lawful to use force against members of the public. BPD's policies fail to provide this guidance. It is also the department's responsibility to train officers to ensure they understand how the department's policies are to be operationalized and to provide officers with skills they need to safely and constitutionally resolve the broad spectrum of incidents they encounter on the street while minimizing the need to resort to force. The department has failed to provide such training. The department is likewise charged with investigating incidents of force to ensure they comply with its policies and the law, and where they do not, remedying officers' conduct throughout retraining and discipline as appropriate. The department has failed to exercise proper oversight over incidents of force and address deficiencies when they occurred, allowing officers to continue using unreasonable force and unsafe tactics. In addition, BPD fails to adequately prepare officers for their interactions with individuals with disabilities or in crisis, and to partner effectively with other social service providers in these incidents. Thus, the responsibility for the pattern or practice of unconstitutional force we observe lies with the department as an agency. BPD's deficient policies have contributed to and permitted BPD's pattern of practice of excessive force. Deficiencies in BPD's policies regarding the use, reporting, and investigation of force have contributed to officers' systematic use of excessive force. Overall, BPD's policies regarding when and how to use force, 1, are missing critical elements, 2, are scattered across multiple documents, making it difficult for officers to synthesize their guidance, 3, included elements that were not enforced, and 4, sometimes inaccessible to some officers. These policies fail to provide officers with clear and consistent guidance that officers need to safely and constitutionally conduct their law enforcement activities. BPD issued revisions to its policies governing officers' use of force on July 1, 2016. The policies appear to have improved in some respects, and the department is to be commended for its initiative and efforts. However, the recent updates may require additional amendments to correct the patterns or practices of unconstitutional force our investigation uncovered. BPD's policies on use of force and on use of specific weapons were, until very recently, missing critical elements. BPD implemented its first policy governing officers' use of batons in 2016. The department's first policy governing the use of oleoresin capsicum or OC spray was implemented in 2015. Despite the previous lack of policy guidance on the use of these weapons, the department had issued these weapons to its officers for decades. It is a fundamental responsibility of the department to provide controlling guidance to officers regarding when they are permitted to use the weapons the department has supplied them. Previously, officers' use of these weapons was governed only by training guidelines, but these training guidelines did not establish clear standards for officer conduct. While the department implemented a policy on electronically conducted weapons or tasers in 2007, this policy failed to provide officers with necessary guidance on when it would be appropriate to use a taser. Training guidelines regarding tasers, which were issued in 2010, similarly failed to provide any restrictions on officers' use of these weapons. Instead, both the policy and guidelines simply provided officers with descriptions of the various modes that the weapons may be used in without providing proper limitations on those uses. Neither the policy nor the training guidelines were updated when the Department of Justice's Office of Community-Oriented Policing Services, in conjunction with the Police Executive Research Forum, released ECW guidelines in March of 2011, which recommended restrictions such as not using a taser more than 3 times on a particular individual. Importantly, until its 2016 policy update, BPD did not require a number of types of force by BPD officers to be reported. This included takedowns, punches, control holds, and pain compliance techniques unless a subject complained of pain or injury resulted. Our review of BPD's report suggests that in practice, force involving an officer's hands were generally only reported if the subject sustained injuries requiring medical attention. Our review of BPD's Force cases, interviews with community members in Baltimore, as well as interviews with officers, demonstrated that a significant volume of force by BPD officers involved officers using their hands against individuals in close encounters, types of force that BPD did not require officers to report until very recently. Force that is not documented cannot be managed or monitored. In our interviews with community members, many members of the public described experiences in which officers used force such as takedowns and control techniques without sufficient justification. These incidents have led to the deep frustrations that some members of the public feel towards BPD. Until July 2016, BPD policies on force failed to encourage any de-escalation strategies. It is critical that officers be provided guidance not only on when and how force may be used, but also that they be encouraged to use tactics that minimize the need for force. Using force against members of the public is not only an intrusion to the subject of force, it also creates risk for officers entangled in these encounters by heightening tensions and creating situations in which officers may also in turn be injured. BPD's new policies have taken some steps to incorporate de-escalation principles, but significant work remains to ensure that de-escalation strategies are understood and utilized throughout the department. Additionally, although BPD implemented a policy governing contacts with youth in June 2015, the policy fails to provide any guidance on the unique qualities of youth behavior and development or prescribes specific techniques for officers' approach and interaction with youth. Second, in addition to missing critical elements, BPD's guidance on when and how to use force, as well as to report, investigate, and review uses of force, is scattered throughout many policies, training guidelines, and their various updates. For example, the rules governing officers' use of their service weapons are contained in at least 4 separate policies and a training guideline on the use of deadly force rather than a single cohesive policy. Additionally, when the department updates a policy, each update is written in a new and separate document. One policy can have many updates, and thus officers are expected to keep track of many different documents simply to understand a single policy. To understand all of the applicable policies governing force, officers must be aware of and synthesize dozens of documents. There is no cohesive, comprehensive guidance for officers that is digestible and workable. Having the critical guidance scattered throughout dozens of disparate documents makes it difficult to understand and operationalize what guidance the department does provide its officers about use of force. In interviews, officers expressed concern that policies were simply implemented and distributed without sufficient guidance regarding the meaning of provisions. A number of officers we spoke with expressed confusion about the content of recently updated policies, including the department's new use of force policy. Third, until recently, officers had insufficient access to departmental policies. Officers received a policy manual in the academy upon joining the department, but later updates to policies were not distributed in a manner that ensured officers received and reviewed the updated policy. Officers receive policy updates through their email, which many officers do not frequently check or have access to because the department computers in the precincts are old, outdated, and frequently break down. Officers are not required to sign off on whether they have received policy updates, and the department had no tracking mechanisms in place to ensure that all officers had received, much less understood, policy updates. To its credit, the department has realized that this is a significant problem and has purchased a new software application to track the distribution of new and updated policies and proficiency testing of officers on the new or updated policies, but that application has not yet been rolled out by June 2016. Finally, the department does not uniformly or consistently enforce its policies. For example, a 1999 policy on reviewing and investigating firearm discharges that was in effect until 2012 included a requirement that each discharge be reviewed by an ad hoc board consisting of a number of chiefs and other personnel appointed by the commissioner. To our knowledge, based on the documents we reviewed, such a review board was never constituted under this policy during the period of our review. Instead, under former Commissioner Bates, a new policy regarding a use of force review board was implemented in 2014, under which a number of reviews were conducted. As we describe in more detail in Section 3 below, the department's failure to consistently enforce its policies has contributed to the pattern or practice of excessive force that we found. These deficiencies in policy guidance, organization, distribution, and enforcement contribute to the pattern or practice of unconstitutional force we observed. All right, I'm going to stop this here and pick up on page 101 in my next video.